happy with the work Ms. Rivers has done for you on your case? Court finds the plea is freely and voluntarily entered and the admission is freely and voluntarily entered. Court accepts it. In 24 CF 1436, you are judged guilty, sentenced to 11 months, 29 days, Okaloosa County Jail. Credit for time served. $305 court cost, $50 cost of prosecution, $100 PD fee, reserve on restitution, concurrent on all cases. In 22 CF 2132, court's going to revoke and terminate probation. Sentence you a judge guilty, 11 months, 29 days, Okaloosa County Jail. Credit for time served, concurrent, $100 cost of prosecution, $100 PD fee. 22 CF 2187, revoke and terminate probation. Judge guilty, 1129, Okaloosa County Jail. Credit for time served, concurrent, $100 cost of prosecution, $100 PD fee.
And Your Honor, just because background noise, I'm not sure if you had mentioned it, he is pleading to a lesser on the 24 CF.
Yeah, I think I said.
Okay,
a
1436 case, pleading to a
Yeah.
misdemeanor.
Misdemeanor criminal mischief, yeah.
Oh, my God.
Yeah, credit for any and all time served, Your Honor.
Yeah, concurrent on everything. How much have you served already?
I violated probation twice, so I think I got 105 days in.
105
that
days?
is.
Huh?
I believe I got 105 days in.
All right, well. About a third there. Okay, all right. In game time, you'll probably be out rather quick. I don't know, but, okay, good. Thank you.
Outstanding monies at hand on probation go to collections, Your Honor.
Yeah. After I'll give him the time to pay it, but after the 11/29,
180 days after his release.
yeah, give him time to pay it. Okay? Oh, I'll order you not to break the law in the future, too. Thank you.
Your Honor.
They always listen to that.
Your Honor, he made a counteroffer, and I just need to convey the state's answer because I just got it this morning.
All right.
Yeah, nothing that bad for him to be doing that.
And I did convey the state to your new offer of 24 with 24 probation, and he is rejecting that offer. And I did indicate to him that you were pulling the offer at this time. Is that correct?
That's correct. The offer is revoked. The state's going to recommend 5-year
So listen.
sentence DOC, and it's going to
didn't
be,
you say,
the recommendations
didn't you
going to be
say he
consecutive.
couldn't-
The pattern
Five-year
of
minimum?
conduct
He
is
can
the same
ask
as
for
the
anything
previous
that he wants.
case, so
But
um,
he can
we're
ask for
seeking the
anything. that he-
maximum penalties.
I think they're asking for 10 years, or they're offering you this 24 months DOC, credit for time served, with 24 months probation.
And Your Honor, he's indicated that he does
years?
not
I
want
didn't
to
hear nothing that
accept
bad.
it. So at this time, we're
All right,
going
we'll
to
see
enter.
you October 28th, okay? Thank you.
Yes. Your Honor, this is Anthony Weeks before the court on 24 CF 498, 24 CF 1534, 24 CF 1989. We've reached an agreement in this matter, if I may approach.
Mr. Weeks, would you please raise your right hand to be sworn? You swear the testimony you give before this court's the truth, so help you God.
Yes, sir, I do.
You want to admit that you violated probation in 24 CF 498 and 24 CF 1534, and in 24 CF 1989, admit that you want to enter it, let's see. No contest plea to failure to notify change in employment,
Yes, sir.
third-degree felony?
Yes, sir.
Okay. Did you read and sign this plea and sentencing agreement form?
Yes, sir, I
Are
did.
you aware of the rights you're waiving by entering this plea?
Yes, sir, I am.
Anyone force you or threaten you to enter this plea?
No, sir, they did not.
Are you under the influence of medication or drugs that prevent you from knowing what you're doing here today?
No, sir.
Are you happy with the work Mr. Rivers did for you on your case?
Extremely.
All right. Court finds the plea is freely and voluntarily entered. Court accepts it. In 24 CF 498 and 24 CF 1534, you're judged guilty. Reinstate community control and extend by 6 months. $100 cost of prosecution on each case, $100 PD fee on each case, waive cost supervision. And 24 CF 1989, you're sentenced to 24 months community control concurrent to 24 CF 498 and 24 CF 1534. Ankle monitor at $1 per day, $4.15 court costs, $100 cost prosecution, $100 PD fee, $50 app fee. Waive cost supervision, judge guilty on all cases.
Thank you, sir.
Okay, thank you.
And Your Honor,
Right.
GPS attached prior to release.
Yeah. Do I need a score sheet on Mr. Wee?
I'm sorry, Your Honor, I'll have to get you that. I'll get you one.
Okay.
That's my bad.
Your Honor, this is Christopher Whitney. He is before the court on 21 CF 848. This is a violation of probation. We're going to enter a denial. My understanding is the case is being transferred down to Judge Ketchell's division where he has a new law.
That is correct, Your Honor, so we have no objection.
All right, good luck to you, Mr. Whitney. Thank you.
Ms. Zell.
Your Honor, this is Terry Ann Zelm before the court on 19 CF 2237. We've reached agreement in this matter, if I may approach.
Okay. Ms. Zelm, would you please raise your right hand to be sworn? You swear the testimony you give for is court's the truth, so help you God.
Yes, sir.
You want to admit that you violated probation in 19 CF 2237?
Yes, sir.
Did you read and sign this plea and sentencing agreement form?
Yes, sir.
Are you aware of the rights you're waiving by entering this plea?
Yes, sir.
You can put your hand down. Anyone force you or threaten you to enter this plea?
No, sir.
Are you under the influence of medication or drugs that prevent you from knowing what you're doing here today?
No, sir.
Are you happy with the work Ms. Rivers did for you on your case?
Yes, sir.
Court finds the plea is freely and voluntarily entered. Court accepts it. Revoke and terminate probation. 6 months Okaloosa County Jail. Waive credit prior to arrest date of August 1st, 2024. $100 cost of prosecution, $100 PD fee, $50 app fee. Adjudicated guilty. Okay? Thank you.
And does money to collections also, Your Honor?
Yes, sir.
Yeah, you're good. Oh, you can go. You can. Okay.
Merrifield indicates she's ready.
Ms. Merrifield,
I'm ready. Morning, Your Honor.
morning.
First case I have, Judge Brainy Merrifield on behalf of Derek Markham. It's spelled Markheim. It should be under Mr. Flaherty, and that's in 23 CF 972.
Okay.
The court would give me just a moment.
Let's go on the plea.
Plea to the bench and set off sentencing.
And what?
Set off sentencing. Plea to the bench, set off sentencing for a PSI.
If I may approach, Your Honor.
Yeah.
And Judge, the score sheet will be provided at the time of sentencing. Mr. Markham is withdrawing his previously entered not guilty plea, is entering a no contest plea in 23 CF 972, and we are requesting a sentencing hearing. I'll give the court the opportunity to read the terms.
All right, Mr., is it Markham?
Markheim, sir, yes.
Markheim? All right. Derek, this is State of Florida versus Derek Joseph Markheim, 23 CF 972. Would you please raise your right hand to be sworn? You swear the testimony you give before this court is true, so help you God.
Yes, sir.
You want to enter a no contest plea, charge of lesser included offense DUI, first offense. I guess that's a misdemeanor, correct?
Yes, Your Honor.
And then count 2 under that same case number, vehicular homicide, a second-degree felony, correct?
Yes, sir.
All right. Did you read and sign this plea and sentencing agreement form?
Yes, sir.
Are you aware of the rights you are waiving by entering this plea?
Repeat that again, sir?
Are you aware of the rights you're waiving by entering this plea?
Yes, sir.
And you fully discussed your rights you're waiving with your attorney, Mr. Flaherty and Ms. Merrifield?
Yes, sir.
Anyone force you or threaten you to enter this plea?
No, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, sir.
Is there any DNA evidence that would be beneficial to the defendant that has not been provided to him and his attorney?
No, Your Honor.
Unknown by the defense.
Is there a stipulation to the factual basis in this case?
Defense stipulates.
State stipulates.
You understand, Mr. Markheim, this is a plea to the bench, and apparently the state and defense are leaving it up to me as to what to give you, although they can obviously argue for what they think is called for. You understand that?
Yes, I do, sir.
There's no plea bargain in this case, so to speak, correct?
Understood, sir.
All right, are you happy with the work Ms. Merrifield and Mr. Flaherty have done for you on your case?
Yes, absolutely, sir.
Court finds the plea is freely and voluntarily entered. Court accepts it and adjudicates you guilty on both counts, and will set a order of PSI and set a sentencing date of what about October 31st?
Judge, we were actually requesting November the 7th at 2 p.m. I did speak with probation. That does provide them enough time to be able to work on the PSI.
Okay, November 7th then. How about that?
At 2 p.m.? Thank you, Judge.
Yeah. Do I need a score sheet on this?
I'll give it to you at sentencing, Your Honor. You won't
Okay.
need it until then.
All right.
And we probably will need maybe 1 hour for the sentencing.
I would
on the
anticipate
7th.
an hour for argument, Judge, yes.
An hour?
Yes, sir.
Okay. All right, well, we'll see what happens. I don't know what's going to happen. I got to hear what everyone has to say, okay?
Yes, sir.
All right, thank you.
Thank you.
And Judge, I have one other on the docket. Brainy Merrifield on behalf of Robert Meza and 23 CF 2868. This is a plea in absentia to misdemeanors, if I may approach.
Okay. State of Florida versus Robert Reagan Mesa, 23 CF 2868. It's a plea to count 1, lesser included offense of misdemeanor battery. He's sentenced to 11 months, 29 days probation to be supervised through Judicial Correction Services, $602 court costs, have a Anger management course, no contact with the person with initials A and G or her family, to include MKG and AG and Jalen Gates or Emily Gates. $4,362.85 in restitution payable to Emily Gates. Count 2. Charged, he just entered this plea to, what's count 2? Simple battery.
Yes,
Court
Judge.
sentencing him to 11 months, 29 days probation. He's to be supervised through Judicial Correction Services consecutive to count 1. No contact with persons with initials A and G or her family, to include initials MKG, AG, Jalen Gates, or Emily Gates. I presume these are minors, correct?
They are. The initials are, indicate minors, Judge.
Restitution amount of $4,362.85 payable to Emily Gates during the consecutive probation terms. Cost of supervision waived. Court reserves restitution for a hearing to determine amount if needed, and withheld adjudication on both counts.
And just so the court is aware, we do anticipate the possibility of restitution maybe needing to be modified, and we'll certainly bring that before Your Honor when that time arises. But he will begin probation today.
Sorry, and that is the state's agreement, Your Honor.
Okay.
And Ms. Merrifield has already provided some records to assist us in determining that probation or the restitution amount.
All right.
He'll check in with JCS within 24 hours, Judge. Thank you.
Okay.
I believe that's all I have today.
All right. Mr. Gil Powell? Did you sign up?
No, Your Honor.
Melody? Where's Mr.? All right, Chris Crawford,
Yes, Your Honor.
come on up.
Your Honor, I'm here on behalf of Mr. Isaiah Drawsand, and we set it for today for Mr. Drawsand to enter a plea. The state has made, as they call it, a de minimis offer to resolve Mr. Drawsand's case. Mr. Drawsand originally lived, or he was working in South Florida, and his parents lived up here at the time of the incident. We've had good contact with him, but when we were making sure that he knew to be here today to get this all resolved, we learned that he was down South Florida working for the company that he used to work for. It's like a road service type company. He can be here tomorrow, but I don't know what the court's docket is like tomorrow. I know this is an older case. I know this has been set to try to get this thing finally put to bed and resolved. We absolutely take the blame in him not being here today. It's kind of part of my Catholic guilt. I'll take a penance a day. But for sure, we want to get this resolved. Everything that needs to be done in the case is done. Every body cam that you can imagine, we've reviewed. There's no depositions that we need to take. We have a full understanding of the case. We just got to get it done.
Is he entering a plea or something, or what?
That was the intention today, would be entering a plea, Your Honor.
The state has no objection to continuing the case so we can get this resolved.
All right,
The offer is going to remain open until the next court date.
I'll say September 26th.
Yes, Your Honor.
If he's not here, he better be in the hospital or something, or I'm gonna put him in jail.
I understand. We will make sure he is here.
All right,
And what's the time on the,
9 o'clock.
thank you, Your Honor. I appreciate it.
September 26th?
Thank you, Your Honor.
Okay. Mr.
We'll make sure it happens.
Yeah, let's do them, because Mr. Powell keeps vanishing somehow or another.
Your Honor, I do have it out of custody, if I may.
Yeah.
Your Honor, I have Mr. Zacchaeus Guerin. Your Honor, Mr. Guerin is present and approaching. Judge, this is 24 CF 1159. Kind of coattailing off of the previous issue. It's kind of my bad that sending some paperwork over to the state to get a PTI contract drafted up. So we're going to ask to set this on the 26th so we can get that paperwork
All
done.
right, September
No objection.
26th, Mr. Guerin, thank you.
Thank you. That's the only out of custody I have for the morning, Judge.
Okay,
Oh, then perfect.
Dixon?
Your Honor, Tim Gibbs on behalf of Akeem Dixon, Judge. This is 18 CF 2695, 19 CF 562, 19 CF 1659, 19 CF 1660, 20 CF 835, and I also have 22 CF 835. I think those are incorrect. Judge, this is a VOP date for Mr. Dixon. I'm going to ask to continue his cases. I just got an offer from the state this morning for all of his cases, including his new law, to cover about 80 months DOC. So we're going to ask to continue so that I can get with Mr. Dixon. I have a few people I need to call from that he's given me, so we can try to see if we can
want
get
to
this
go to
resolved.
what? What date you want to go to?
I'd like to leave it, actually, if I could, and track with the new law on 24 CF 1598 on 1028.
All right, October 28th.
I'm sorry, Your Honor. No, I would ask that it be placed on a miscellaneous for a VOP evidentiary. The new law will be resolved with the VOP evidentiary. He has a suspended sentence that this court imposed prior to today. So
What, we got October 31st? Is
that would
a
be
date?
fine for the state at 2 p.m. with subpoenas, unless
All right.
he admits. I don't know.
Okay, October 31st.
2 p.m. Thank you.
What date was that? I'm sorry, Judge.
October 31st.
31st? Thank you, Judge. Welcome, Steve.
Douglas?
Your Honor, Tim Gibbs on behalf of Joshua Douglas. This is 24 CF 1226, 24 CF 1678. Also, my bad on this one, Judge. I was hoping to file a bond motion, but I was not able to. I'd like to set him on 926 to get a bond hearing done.
All right. September 26th.
Paul?
Your Honor, Tim Gibbs on behalf of Sean Falk. Judge, this is 23 CF 1946. Was recently appointed to Mr. Falk's VOCC here. I do need discovery. I don't have an offer from the state, so I'm going to ask to enter denial for him and put in, if we could, for 926 without subpoenas.
Okay, 926.
This- Gotcha. Your Honor, while we're waiting on my next inmate, I do have one on the afternoon docket, Mr. Andrew Gormley, 24 CF 918, 24 CF 1248. He is actually in DOC right now on some Santa Rosa and Escambia charges. We're working to resolve the Okaloosa charges concurrent with that. I just need to be able to go meet with him. He's, I believe, in Chipley. I'd ask to go ahead and enter not guilty pleas for him all around and leave him on 1028 if possible. As well as, I believe he was set on the 916 jury trial docket for some reason. I'm not sure. There may have been an order that was signed. We'll just ask to cancel that since he's not set for trial.
Okay, so October 28th for, this is Gormley?
Gormley, yes, Your Honor, for pretrial. Yes. Your Honor, Tim Gibbs on behalf of Mr. Travis Feeser, Judge. This is 23 CF 2124. We haven't gotten an offer from the state yet, at least I hadn't as of this morning, so I'll ask to put him on 926 as well without subpoenas.
926.
Thank you, Judge.
Thank you.
So I'll come see him. I just don't have an offer from the state, so I don't know what they're looking for yet.
We got some out of custody out there that have Do y'all have attorney, anyone out there that does not have attorney but is supposed to be here today? All right. Was it Brouchard? All right, I'll start with the lady in the black shirt right there. Come on up. Are you supposed to be here this morning or this afternoon?
This afternoon.
All right, what's your name?
Lacey Alford.
Oh, Your Honor, I represent Ms. Alford. Come on over. Your Honor, this is Ms. Lacey Alford, Judge. She's supposed to be here for arraignment this afternoon, 24 CF 1812. We'll enter a not guilty plea request 15 days for any pre-arraignment motions and demand trial by jury.
All right, October 28th, thank you.
Thank you,
Thank you,
Judge.
sir.
All right, give me a call.
Who was on that very next, Mr. Red Shirt?
What's your name, sir?
What's your name?
Donald Davis.
Davis?
He's on the 9 o'clock. He's a pro se.
Come on up here, Mr. Davis. Says he's here for a hearing. Is he here for arraignment, or have you been appointed an attorney on these charges?
There's no charges, sir. I put a petition in for modification of
Oh,
probation.
yeah, that's right. I'm sorry. Yeah.
Is this Mr. Davis, Your Honor?
Yeah.
I'm sorry, we didn't hear it. You want to do it?
Yes, Judge, we have no objection to probation modifying his curfew for work or school purposes.
Yeah, it was the curfew request.
Yes, sir.
Okay, I'll just, what was the time change you wanted?
It's just to be able to change my curfew. I was arrested in Okaloosa County. I now reside in Volusia County, so I'm not able to change my curfew without
Yeah.
putting a petition in here.
Well, would the state just send me a simple order
Sure.
granting the petition, the curfew change? Oh,
Your Honor, I think we can do that if he's on probation.
all right.
And if the court, if I'm hearing this correctly, if the court will, since he's being supervised somewhere else and we don't want to have to keep coming back, if you would just allow probation to adjust curfew for work purposes, then we can handle it from there.
All right, that's good.
okay with the court.
They'll send an order. Okay, I grant it.
Yes, sir. Thank you, sir.
Okay, thank you.
We should also have Aurora Bouchard.
Aurora Brouchard. She's here on a violation of probation. Is it an arraignment or something? Is there a offer?
There's an offer. The state's offer for admission would be to extend her probation for 6 months for her to comply with ECLC and pay whatever court cost.
You want to do that?
So, my probation officer, he was gonna ask for a modification of the ECLC. He had me go ahead and go to Pattison in Fort Walton and get an evaluation done. They didn't have any substance abuse recommendations for me, so.
If we can get that in writing, that would be useful because I've reviewed other cases that Ms.
Why don't we
Bouchard
just
is
continue her to
involved in.
September 26th?
Sounds like a prudent.
Okay?
idea.
September 26th, and get that, some paperwork to Mr. Sprouse and
Okay,
state attorney, and we'll take a look at it, okay?
okay, yes, sir.
If she could bring it to court, or email it to my office.
Yeah, I actually just texted my probation officer asking him if he submitted it to you guys, but I guess he didn't.
I'll look into it, Jeff.
All right, September 26th, come back at 9, okay?
Okay, thank you.
We had Jonathan Ezra.
Ezra, was there anyone else back there that I missed over here that doesn't have an attorney? You are Ezra, Jonathan Ezra.
Yes, sir.
Was this a request for modification
Yes, sir.
also? Refresh my memory on it, because I get these all the time. What do you know?
Judge, the defendant was convicted of a sex offense with a 17-year-old female. He was 31 at the time. He was placed on sex offender probation, and he was ordered no unsupervised contact with minors. He's seeking to live in the home with his wife and her minor children. He's also seeking contact with one of his children. The issue is, even though he has no unsupervised contact already, he cannot live in the home. He did submit a risk assessment. However, we need written consent of the guardian of these specific minors, saying, I'm aware of the charges, and I want my child to have unfettered access to this defendant.
The mother to the children's here, man.
Well, we need it in writing, so what we'll do is continue it to September 26th and see if you can get that paperwork to the state, okay?
Sir, is there any way I can get that telephonically? I live in North Alabama.
No, not if the statute requires. Is the statute required in writing, or is that just your requirement?
Is it statute or is it testimony? Is it statute or testimony? It needs to be written.
Statute requires that? A request by the guardian in
It's the
writing?
rules of probation.
Pardon?
It's the rules of probation. I spoke with them this morning. They need the consent of the parents saying, I'm aware of what's going on and I'm allowing access to my child. He has a risk assessment. He just needs this piece.
Is that probation out of Alabama or somewhere, or?
Yes, I spoke with probation here this morning. I didn't speak with Alabama.
Your Honor, I'm sorry, I missed something. He's wanting to have contact with,
Unsupervised contact.
With his own child and his, I guess, new wife's kids, is that right? Is that what you're?
My stepchildren. Because
Stepchildren.
it's worded no unsupervised visits with the minors. Alabama will not allow me to live with my family.
I understand that, we wouldn't either, unless he completes the risk assessment, and if the risk assessment says that they have determined him to be able to have contact with them, then we would need some guardian to tell us.
Well, did he file a risk assessment? Does he have a risk assessment?
There's a risk assessment filed with the court. I can approach if you'd like.
Yeah. Well, he does have a good risk assessment. Well, I can't represent you, so you need to figure out what else you need to do. And we'll set it for September 26th and see about, you need to get me whatever written guardianship consent or whatever it is you need. I don't know what you need to do on your case. I can't tell you what to do. So we'll set you for September 26th and see if you can get an attorney to figure it out, or you can figure it out and get me the paperwork I need, okay?
Yes, sir.
Thank
9
you.
o'clock.
Yeah,
Thank you.
September 26th. Who else out there raised their hand? Mr. Powell, I called you a couple of times, but you weren't ready, so I'm not trying to give you a hard time, but every time I've called you about 3 times, I look and you're gone. So you're there, you vanish. Some invisible cloaking mechanism got going there, I guess. All right. right, so are you ready?
Ready.
Come on up.
Thank you. Tara Overstreet, Judge.
Tara Inez Overstreet.
Right.
Okay.
You got it? 23? We got a plea, Judge.
23 CF 2032, State versus Tara Inez Overstreet. Miss Overstreet, would you please raise your right hand to be sworn? You swear the testimony you give for this court is true, so help you God.
Yes, sir.
Okay. All right, you want to enter a no contest plea to larceny, grand theft, is it first degree, over $100,000, correct?
Yes, sir.
And also count 4, illegal use of credit cards more than 2 times in 6 months to obtain goods more than $100, correct? Another,
Yes, sir.
that looks like a 3rd degree felony. And the state's going to dismiss counts 2, 3, and 5, correct?
That is correct, Your Honor.
Did you read and sign this plea and sentencing agreement form?
Yes, sir.
That first count, is that a 2nd degree felony or
First count is first degree felony.
1st degree felony? Okay. So did you read and sign this plea and sentencing agreement form?
Yes, sir.
You aware of the rights you're waiving by entering this plea?
Yes, sir.
Do you have any questions about the rights you're waiving by discussing it and with Mr. Powell?
No, sir.
Are you happy with the work Mr. Powell did for you on your case?
Yes, sir.
He want to force you, threaten you to enter this plea?
No, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, sir.
Is there a factual basis stipulation?
State stipulates.
Court finds the plea is freely and voluntarily entered. Court accepts it. On count 1, you're sentenced to 36 months, Department of Corrections. Standard court costs, restitution amount of $400,000, payable within 12 months of release, or it will go to a judgment. Well, this says she's not going to be sentenced till October 31st, right?
Correct. We'll ask you to accept the agreement, Judge, and then come back on the 31st for sentencing.
Okay, well, we'll do that then. If I find the plea is freely and voluntarily entered, court accepts it. So defer sentencing till October 31st. Write defer sentencing up top, not to the very last thing that I read, you know? So October 31st, we'll see you. 9 o'clock.
Thanks.
Okay?
Thank you, Judge.
I guess I need a score sheet by sentencing time.
Didn't I have
Oh,
one?
yeah, you did. Thank you.
Thank you, judges.
Okay.
Last case I got, Judge, is what took the time was
Who?
Megan Valdez. It's 22/17/76. That's where all the work's been. I've got a plea, Judge.
Okay. State of Florida versus Megan Allen Valez, 22 CF 1776. want to enter a no contest plea to count one. Oh, did I swear you in? Would you please raise your right hand to be sworn? You swear the testimony you give for is course of truth, so help you God.
Yes, sir.
You want to enter a no contest plea to count 1, 2, and 3, failure to report suspected child abuse, and count 4, 5, and 6, child neglect without great bodily harm, correct?
That's correct.
Did you read and sign this plea and sentencing agreement form?
Yes.
Are you aware of the rights you're waiving by entering this plea?
Yes.
Anyone force you or threaten you to enter this plea? Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today? Is there a stipulation on a factual basis?
Yes, there is, Judge.
Are you happy with the work Mr. Powell's done for you on your case?
Absolutely.
Court finds the plea is freely and voluntarily entered. Court accepts it. Adjudication withheld on all counts. You are, let's see, you are placed on 6 years probation. Is it, are these third-degree felonies?
Yes, Your Honor.
Yes, Your Honor.
So we have to do a 5-year probation on count 1 and a consecutive 1-year probation on count 2. How about that?
2 through 6, Your Honor, and make those concurrent with each other?
Yeah.
Thank you.
All right, so count 1 is 5-year probation, count 2 through 6 is 1-year probation. Consecutive count 1, but concurrent with each other.
Correct, Your Honor. And we're
Correct.
asking for a no contact with the victim or families.
No contact with victim or victim's family. And standard court cost of supervision, cost of prosecution, I guess. What else? Anything?
That covers it, Your Honor.
Is that it?
Yes.
Can we waive that, any way to waive that cost of supervision? I mean, she's struggling pretty good.
All right, cost of supervision waived. Is there some type of, did I sign a score sheet?
Your Honor, I'll have to get the court the score sheet.
Okay,
Apologize.
thank you.
That's where the problem's been, Judge. We've been trying to work on that one. We got it done. Thanks a lot,
Okay.
Judge.
Thank you.
That's all I have, Judge. Thanks.
All right, thank you. Ms. Flowers?
Sure. Is Watson on there too? Oh, okay. For the record, Your Honor, good morning. Jennifer Flowers with the Office of Regional Conflict on behalf of Joshua Jackson in case number 24 CF445. We're asking to set this back on the trial docket October 28th. The state did not accept our counteroffer. The state has made an amended offer, and there is an outstanding report that I need to get from the state and go over with Mr.
Okay.
Jackson.
October 28th. Thank you.
Thank you. Your Honor, for the record, Jennifer Flowers with the Office of Regional Conflict on behalf of Aaron Knopfsinger, case number 23 CF 2422. We're here today on a motion we filed for an order to depose the minor children, the minor victim in this case, as well as the minor witness. In the motion filed, it has the date of birth, 7 years of age. At the time of the alleged incident is the victim, and the alleged child witness was 6 years at the age of the alleged incident. We're just asking that the court grant us the ability, an order allowing us to depose the child victim as well as the child witness to get a direct statement from them regarding the facts of the case and allegations.
Your Honor, the state is definitely opposed to this. Under 92.556B, the court has the discretion to allow this. The state is opposed to it. The court is directed generally to lean towards not allowing it if there are specifically other means from which the defense can get the information that's sought. In this case, Your Honor, there's a great deal of other avenues for the defense to get the information that's sought from these children. The children gave disclosures to law enforcement and DCF. The defense is aware of those. They also gave the forensic interviews that were recorded, and that the court is familiar with the forensic interviews, the open-ended questions. So the children gave detailed disclosures, the victim did. And then additionally, Your Honor, the defense also has the benefit of the repeated and detailed confessions of what happened from the defense or from the defendant himself. So we do not believe that there has been any showing that there's any additional information that can be gained. And again, under the statute, the legislature has determined that it is not appropriate to take the depositions of child victims if that is reasonably available through other means. So we are opposed to that, Your Honor.
Well, you have all that information through the forensic interview with the children, I guess, and I'm going to deny your motion. So,
Thank you, Judge.
Thank you, Your Honor.
And Your Honor, Jennifer Flowers on behalf of Terrence Parker. We're here for a bond hearing. Your Honor, he currently does not have a bond in 23 CF 1799, which is a VOP, and 24 CF 1239, which is a VOP. As stated in the motion I filed, he was arrested on July 31st, 2024 and charged with fleeing, attempting to elude, driving as a habitual traffic offender, resisting without violence. And these alleged criminal acts happened on June 25th, 2024. The issue here is the identification of Mr. Parker as actually driving the vehicle. I do need to conduct depositions of the officers to see what's going on there. He does have a bond, a $25,000 bond on the new charge, but was denied bond on his VOPs. This defendant owns his own business, CMC Lawn Care. When he was arrested, he was actually in his work attire, had been at work. He provides for his wife and 3 minor children, one of which has a disability that requires specialized care. Also, his wife, who I believe is present, is currently pregnant, and they're just under a lot of financial stress right now. He fully intends to appear for court, and he has no prior failures to appear. He just is asking that the court set a bond on his VOPs so that he may be out of custody and continue to work and provide for his family while these charges are litigated. He was saying he's not opposed to an ankle monitor or any condition of pretrial release. He simply just wants to get back to work while these cases are litigated, while this new case is litigated. So we're respectfully asking that the court set a bond on the VOPs. We're asking for signature bonds. He says he's already behind on his rent.
Charge is what?
The new charges are fleeing and attempting to elude, driving with license suspended as a a habitual traffic offender and resisting without violence. I attached the probable cause affidavit as an exhibit to the bond motion, which states that the officers, quote, the that he had the defendant, we were unable to, pursuant to the probable cause affidavit, they were unable to actually identify him as the driver of this vehicle that fled. And those charges are all based on basically what I believe to be their inability to identify them. Again, I've since then gotten a full narrative wherein he is identified, but it still doesn't say how. The windows were dark. The person that was driving the vehicle fled. So I just believe that depositions need to be done, and we need to get to the bottom of this, whether this can be proven that it was Mr. Parker that obtained these new charges or not. We are saying it's not, but it's going to take a while to get depositions set, coordinate depositions with the state, get this set for trial, and we're just asking, he's pleading with the court that he be allowed to continue to work in the meantime.
Your Honor, according to my record, he's in his prior record as a second-degree burglary. That would qualify him for a violent felony offender of special concern. Additionally, the court found probable cause of first appearance. This whole issue of identification, I do not see it at all. I totally disagree. The defendant has a pretty long criminal history. He scores a minimum guidelines of 49 months and a maximum of 30 years. I would ask that he remains without bond on the VOPs.
And Your Honor, the state is relying on, and she let me know that she was relying on the or wanting to qualify him as a violent felony offender of special concern. I believe the state's relying on an adjudication of delinquency in 2003 pursuant to Florida law statute 985.356. A juvenile adjudication is not a criminal conviction and cannot be relied on for reasons of qualifying the defendant as a violent felony offender of special concern.
It was 21 years ago.
And that was in 2003.
If I can speak, Your Honor.
Usually when people talk, they hurt their cause. So, was any police officer allegedly hurt in this episode?
No, Your Honor.
Do you have any prior violence of anything? Any violence on anybody?
He has a prior felony battery, in which his wife was the alleged victim. They have told me that they were pressured into entering it. She also entered into a plea agreement based on a mutual combat situation. She is here to speak on his behalf.
Your Honor, if I may, his prior record includes 6 driving while license canceled, 1 driving while license revoked felony, petty theft, battery, domestic violence, resisting officer without violence, 3 charges, grand theft, 2, grand theft of a motor vehicle, 6, fleeing or attempting to elude the second-degree felony, 2 of them, burglaries of an occupied conveyance, 8 of them, and then felony battery, the one, and burglary of occupied dwelling, and another felony battery. So just with the VOP points, he would score prison, even if we didn't go forward on the new law. If this was set for an evidentiary hearing, I need only a preponderance of the evidence. And again, just on the VOPs, he would score prison time. And that's what the state is seeking. I believe it's a danger to the community with all the prior record, and he keeps.
How long ago with all those priors?
Except for, they're not very old, Your Honor. I can pull it up. I mean, he was on probation, so.
He's saying it's over, he's been out of prison for 8 years, and that those charges that the state was referring to all were before his time in prison, which he's been out for 8 years.
Yeah, and that's the reason why they may appear old, because he was in prison for 8 years. And
No,
as soon
he's
as he
been
got out.
He's been out for 8 years.
long was he in prison?
The last time I did 4.5 years.
4 years?
4.5, yes, sir. I've been
He
owning my
fully
own
intends
business.
to participate, and I've been in contact with his wife almost daily. She has my cell phone number. We fully intend to litigate this matter. He's just asking.
$5,000 signature bond per VOP, pretrial services supervision, ankle monitor, $1 a day, and you better not even think about getting in a car.
What about
Oh,
the,
thank-
what about the other two?
Please.
Other two what?
The other, he's referring to the $25,000 bond on his current cases. Could we convert those to signature as well?
$5,000 cash or professional on all of them, from 25 to 5.
Thank you, Your Honor. I'll prepare an order.
Each one, whatever however many 25s there are.
That's total.
Okay. Well, 5,000 cash or professional.
No, it's.
And if you mess up,
I'll prepare an order. Thank you, Judge.
you're gonna get no bond. Okay? All right, thank you.
Thank you, Judge.
And Your Honor, just for the court's understanding, he will be on GPS with pretrial services, but he is still on probation.
Oh, yeah, still on you still gotta check in with probation, everything.
But pretrial services will need to hook him up prior to release.
All right.
Your Honor, this is Taquan Watson. We're here. I have him set for a bond hearing, and I do acknowledge that we'd had a pretrial detention hearing, I think, on August 8th, and there have been no changes, substantial changes factually. But I'm asking the court to consider some non-factual circumstances and reevaluating his bond. The court set a $10,000 per count for a $30,000 cash for professional bond. What I'm wanting to present to the court today, and I am acknowledging there's been no factual changes, but I have been in contact with his mother since then, and she has informed me that she cannot post such a high bond. And in addition, she is extremely terrified, as is the defendant, that he is not safe in the Okaloosa County Jail. His stepfather, Termichael Henderson, was killed inside of the jail in June of this year, and his presence in the jail is his mother is just terrified.
What's his prior record?
Possession of firearm by a convicted felon, discharging a firearm in public, burglary of an occupied dwelling, grand theft of a firearm, grand theft, discharging a firearm, possession of weapon during the commission of a felony, aggravated assault by threat with a deadly weapon. Sorry, Judge. 2 batteries, resisting officer with violence, tampering with evidence, resisting officer without violence, burglary of an occupied conveyance, 6 of them, and petty theft. He is currently charged with burglary of conveyance, armed with explosives, grand theft, and two counts of grand theft of a firearm. I believe this case was set for a pretrial detention hearing, and the bond was set at the time, so there is no change in
I'm
circumstances.
gonna say, there's too much firearm, too much danger there, so I'm gonna leave the bonds the way it is. Thank you.
I understand. Thank you, Judge.
Thank you.
And I believe that's all I have on this morning's docket, if I may be excused.
Got someone with a case, I guess. Oh, well, there's too much firearm danger. I gotta leave them bonds where they are. All right, talk to Ms. Flowers. She'll talk to you. Thank you. We got Ms. Dudley or Ms. Reed, or who we got?
Your Honor, we do have a case, but we have multiple motions on it, so we figured it would go later in the docket.
Okay.
Your Honor, I do have one housekeeping matter, if I may, that's on the docket. Mr. Grayson Poland, case number 24-1401, is represented by Mr. James Heath. I do have a executed deferred prosecution agreement that's been signed by Mr. Heath and his defendant. Would the court like me to provide that to the clerk here or to e-file it separately?
You can provide it. You can
Thank you. If I
provide it
may, I'll
here.
just
Yeah,
approach.
yeah.
And then that would take that off the docket for today.
All right.
I did indicate to Mr. Heath I would take care of that for him.
Is Michael Flowers supposed to be here today, or do we do his?
May I approach, Judge?
What?
May I approach?
Okay.
I won't speak about the specific cases. There's a hang-up with the clerk's office. They need something in writing. So my request is if Madam Clerk can put that the defendant is to pay $665 in court cost on the minute sheet, so then I can relay that to the defense and we can get this case resolved.
All right. We'll order that.
Thank you, Judge.
And I'm ready for them, Judge.
Well, hang on one second. Are they all gonna be pleas or motions or?
Judge, there's one that's going to be in the morning group that's gonna be an arraignment. There's gonna be a few that are gonna be pleas. Destiny Lige and Kevin Lack, I haven't heard anything back from the state on it. I was trying to get a county jail sentence on Kevin Lack. And Destiny, we were trying, that's the lady that's been in Florida State Hospital, and we were trying to work something out for a withheld cost.
That's gonna be the recommendation, okay?
Okay.
For the first case for Lige.
I'm gonna take about a 15-minute break.
All right, Judge, that'll give us a chance to talk.
For Lack, not, I mean, I do 14.
All rise, please.
Not going back.